change for cannabis use in South Africa. The Health Ministry has proposed amendments to the Medicines and Related Substances Act, which, if passed into law, would allow for cannabis plant material and products containing it to be used for private consumer purposes without being regulated as a Schedule 6 substance. However, this comes with the caveat that it will only qualify if the products have no pharmacological action or medicinal purpose. According to Altair Richards, an executive at ENS Corporate Commercial Practice, this change would mean that more products that are currently regulated as Schedule 6 substances will, following the publication of the final amendment to Schedule 6, not be regulated as Schedule 6 substances. This adds an important step to South Africa's journey of decriminalizing cannabis use and clearing up the regulatory minefield surrounding its use, both privately and commercially. Proposed changes unpacked. Cannabis contains a large number of active components called cannabinoids. Two cannabinoids that have had particular focus in legislation are the tetrahydrocannabinol and CBD cannabidiol. CBD was downscheduled back in 2019 to a Schedule for substance, with an exception notice wholly descheduling certain CBD-containing preparations and products. This was followed by a significant rise in consumer products on the market containing the substance. However, until now, the lick in cannabis has remained verboten, unless in negligible doses. Historically, products containing the were defined as being a Schedule 7 drug, the same schedule as narcotics like heroin. However, this changed to Schedule 6 following the Constitutional Court's ruling in 2018. Schedule 6 and Schedule 7 are narcotics and other controlled substances and poisons like morphine. These are not easy to access and, according to South Africa's Medical Society, are only used in extreme cases. Scheduled substances may be listed in more than one schedule based on the dosage form, route of administration, strength, indication, dose, duration of treatment, or a combination of such factors, said Richards. In effect, products, including products for human consumption, will not fall within the scope of Schedule 6 if they have no pharmacological action or medicinal purpose, in contrast to the current regulatory regime, which excludes products from Schedule 6 based on a set percentage of the content. She said, while the proposed changes appear to be another big step for opening up and decriminalizing the private use of cannabis in South Africa, Richards noted that there are other parts of the country's laws which still do not align. Specifically, amendments to the Drugs and Drug Trafficking Control Act and relevant schedules still need to be made to ensure that cannabis use is above board and lawful. Currently, the Drugs and Drug Trafficking Control Act stipulates that no person shall use or have in his possession be any dangerous dependence-producing substance or any undesirable dependence-producing substance. Its current scheduling specifies that undesirable dependence-producing substances include cannabis daga, the whole plant or any portion or product thereof, except dronabinol trans-delta 9-tetrahydrocannabinol. The Constitutional Court in 2018 upheld a ruling finding that sections of the Drugs and Drug Trafficking Act were unconstitutional, leading the way to the decriminalization of private cannabis use in South Africa.